Hi guys, and welcome to another episode of Atty. Vlogger, Law for the Everyday Layman. Today we take up part 2 on the Personal Property Security Act or Republic Act number 11057, and we'll be talking about the priority or preference of security interests. Okay? Shout out to Charmaine Faith Kabuhat for her assistance in these videos, no? And please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Also, if you like my videos and you want to see more, please hit the subscribe button. Okay? Now, when we talk about priority of security interests, the implementing rules and regulations of the PPSA, okay, short for Personal Property Security Act, defines priority as the right of a person in an encumbered asset in preference to the right of a competing claimant. In other words, this is the preference of the secured creditor in payment. He gets to be paid first before others. Okay? So this amends the rules on concurrence and preference of credit with regard only to movable property as found in the Civil Code. Specifically, the PPSA under its Section 66 amends Articles 2241, 2243, 2246, and 2247 of the Civil Code insofar as the preferences stated in those articles are inconsistent. Okay? Inconsistent with the priority rights of the secured creditor which are perfected under the PPSA or its implementing rules and regulations. Now, the general rule, as stated in the implementing rules and regulations, is that the priority of security interests or liens on the same collateral, no, is determined according to the time of the registration of the notice in the registry of the Land Registration Authority or perfection by other means, okay, without regard to the order of creation or to the mode of perfection. Meaning, as a general rule, we just look at the time of registration or perfection by control or possession, no? It is that time by which we will determine the priority of the security interests. Okay, so now let's go to the specific rules. First, let's talk about deposit accounts, no? Deposit accounts meaning those made with deposit-taking institutes such as banks, okay? So, the first order of preference, as stated in the implementing rules and regulations, no, would be any rights which the deposit-taking institute or the bank may have to set off, okay, set off or compensate against the grantor's right to payment of funds credited to the deposit account. Okay, they shall have priority over any security interest in the deposit account. Okay, the right to set off or compensation. Okay, so just remember the case of Gulas versus National Bank, okay, or Gulyas versus National Bank, which was taken up in obligations and contracts under compensation, as well as in the topic of loan in credit transactions, okay, in which case the depositor and a bank have a creditor and debtor relationship, and under this case, no, it said that a bank has the right to set off or compensate a deposit in its hands for payment of any indebtedness to it by the debtor, okay, because of the creditor-debtor relationship between the depositor and the bank. Okay? Okay. Now, that's the first rule of preference. Next, in case of a security interest in a deposit account in which the secured creditor is the deposit-taking institute or bank or an intermediary, then that is the first preference, okay? Aside from the first one I mentioned in set-off and compensation. The next is a security interest in the deposit account or investment property which is perfected by a control agreement. Okay? Those are the three, no? Now, what if there are several security interests that are conflicting or competing, no? And all of them are perfected by control agreements. How do you know which one comes first? Then, we determine the priority as of the time of the conclusion of the control agreement. If you will remember in my previous video, a security interest over, in case it is done through if it is perfected through a control agreement, that control agreement must not only be in writing, but it must also be under oath, okay? Under oath, meaning notarized, no? Why? In order to determine the time and date of perfection. Okay? So that's it for deposit accounts. Again, first, the set off for compensation. Next, if the security interest is in favor of the deposit-taking institute or intermediary. Next, if the security interest is perfected by a control agreement. After all those, everything else comes next. Okay? Next, let's talk about electronic securities. Okay? There are two scenarios here, no? Electronic securities which are not held by an intermediary, and electronic securities which are held by an intermediary, okay? So, first, no? In case the security interest over the electronic security is not held by intermediary, then these are the rules of preference, okay? First in the line of preference are those which are perfected by notation in the books. Okay? The books of the entity. Okay? Next in line is those that are perfected by a control agreement. Okay? If they are perfected by a control agreement, then they take priority over those that are registered by notice with the registry. Okay? So again, perfected by notation, then perfected by control agreement, then those by registration of notice. Now again, what if there are competing security interests and all of them are covered by their respective control agreements? Then again, we just determine it by the time of the conclusion of the control agreement. Okay? Again, it's under oath, and that is what we will use to determine when it was perfected. Now, as for the scenario where the security interest over the electronic security is held by an intermediary. Earlier, it's not held by an intermediary, but now it's held by an intermediary. Okay? If that is perfected through a control agreement, then the rule is simple. That will take priority over all the others. Okay? Again, if it is held by an intermediary, if it is perfected through a control agreement, then that will take priority over the others. Now, let's talk about this animal called a purchase money security interest. Okay? Or PMSI, purchase money security interest. What is this? This is a security interest in goods. Okay? It's the interest that attaches to the goods which is taken by the seller to secure the payment of the price by the buyer. Okay? Or, it is secured by a person who gives value to enable the grantor to acquire goods to the extent that the credit is used for that purpose. Okay? So, this enables the buyer or the grantor to obtain goods, okay? Or in case of the seller, it secures the payment of the price, okay? Now, these are the rules when it comes to the PMSI, okay? If the PMSI is in equipment and its proceeds, or if the PMSI is on consumer goods, then they will have priority over other conflicting security interests over the same subject matter if the notice is registered within 3 business days. Take note, business days, not calendar days. Registered within 3 business days before from the moment that the grantor acquires the goods. Okay? From the moment that the grantor receives the goods or the equipment. Okay? Now, what if there is there's a third person who acquires a right over the goods, such as a buyer, a lessee, or some other lien holder, no? The rule is, if the PMSI, no, the purchase money security interest, is perfected in accordance with the rule I mentioned earlier, yung 3-day rule, no? If it's perfected timely, then the secured creditor shall have priority over the rights of a buyer, a lessee, or a lien holder which may arise in the time between the delivery of the goods or equipment to the grantor and the time of registration of notice. Okay? So, the secured creditor may still get a better right even if mauna yung buyer, lessee, etc. as long as he registers the notice within 3 business days from the time that the grantor receives the equipment or goods. Okay? Now, let's go to another rule, no? What if the PMSI, no, the purchase money security interest, no, is over inventory, intellectual property, or livestock, no? That's possible, okay? Again, inventory, intellectual property, or livestock, okay? Priority for the PMSI in these cases will exist, no, if it is perfected, if the PMSI is perfected when the grantor either receives possession of the inventory or the livestock or the rights to the intellectual property. And okay, this is important, no? So there are 2 here, no? The PMSI on inventory, intellectual property, and livestock will be perfected if first the grantor receives the goods or acquires the rights over the intellectual property, and second, the secured creditor must give a written notice of his security interest to the conflicting holder of the same security interest over the inventory, intellectual property, or livestock, no? He must give a notice to the holder before the grantor acquires the possession or rights over the inventory, intellectual property, or livestock. Okay? Now, this notice that the secured creditor must give, okay, it can cover multiple transactions. Meaning the secured creditor or the grantor, they don't have to identify each transaction in that notice to the holder of a conflicting interest. Okay? Just giving one notice to cover multiple transactions is enough according to the implementing rules and regulations. Okay? So again, the PMSI or purchase money security interest over inventory, intellectual property, or livestock will be perfected upon the happening of 2 things. First, if the grantor receives possession or rights to the inventory, intellectual property, or the goods, or the livestock rather, sorry. And second, the more important one is if the secured creditor gives written notice to the conflicting holder about his security interest before the grantor receives the inventory, intellectual property, or livestock. Okay? Now, with regard to the livestock, no, there is an order of preference, no. There will only be a priority in that case, as I mentioned earlier, if the buyer receives the livestock and if the secured creditor gives the required notice to the conflicting holder. Remember, those are the 2. What if the secured creditor is not able to give the notice? Then of course the priority is lost, no? The rule now in case of livestock only, livestock, okay, is that if the secured creditor fails to give the written notice to the conflicting holder of the security interest over the same livestock, no, then priority is now given to the security interest in the livestock which secures an obligation that is incurred to enable the grantor to obtain food or medicine for that livestock. Okay, so that is what has priority now. Okay, the security interest which the grantor gets to secure an obligation which is incurred to buy food or medicines to feed those livestock. No, let's say it's cows, whatever, no, livestock. Okay, so in that case, that has priority if the secured creditor fails to give written notice to the holder. But if, of course, if the secured creditor is able to give notice to the conflicting holder before the grantor receives the goods, and then the grantor receives the goods, then of course, the purchase money security interest will then be perfected, and therefore we have priority over those for food or medicine. Okay? Just remember that rule, no? Now let's talk about negotiable instruments, negotiable documents of title, or security certificates. Okay? A security interest in security certificates, negotiable instruments, or negotiable documents of title, no, will be perfected by possession of the secured creditor. Okay, of those certificates, instruments, etc. No, and it will have priority over security interests, which are perfected by registration of notice in the registry of the LRA. Okay, so possession in case of those instruments will prevail over registration. Okay, now let's go to other specific rules. Okay. A person who provides services or materials with respect to goods in the ordinary course of business and retains the possession of those goods shall have a priority over the perfected security interest in goods until he is paid. Okay? This is consistent with the provisions of law that those who have rendered service can have a right to retain the object until they are paid, no? Okay, so this rule here in the PPSA simply reinforces that other rule I just mentioned. Okay, and finally, what if the grantor becomes insolvent? Okay, is the security interest lost? This is the rule under the PPSA and its IRR, no? Subject, of course, to the applicable insolvency law. The security interest which is perfected prior to the commencement of insolvency proceedings against the grantor shall remain perfected. Okay? As long as it was perfected prior to commencement, it shall remain perfected and it will retain priority that it has before the commencement of the insolvency proceedings. Okay? As long as it was perfected prior to the commencement of insolvency proceedings, then it will remain perfected and retain its priority. Okay? As long as it was perfected prior to commencement. Okay, now, during the insolvency proceedings, what is the status of the security interest, no? The perfected security interest shall constitute a lien over the collateral which may be included in the insolvency proceedings. Okay? So that's it for the priority of security interests under the PPSA and its IRRs. Please just wait for my next video on enforcement of security interest. Okay? So I hope you may have picked up a thing or two, and I hope to see you soon. Okay? Bye!